Okay, the law title or the presentation title, you can read it. I'm not going to. It took me way too long to type. The one thing that I've learned over the past 2 days, and I wish there were more people here for this, but the one thing I've learned is that there is no more wretched hive of scum and villainy than this place that I've seen thus far. I have seen misrepresentation, copyright infringement, reverse engineering violations, and there's a certain amount of stalking going on. As an attorney, this concerns me, but I'm also an information security professional, in all seriousness. That's where I started. I started more on the information security / IT side. Now, I've also run my own business. I've run a bookstore. I've run a consulting company. I've been both with business, information security, and I'm also a licensed attorney. So I'm somewhat all over the place. Plus, I'm a notary public in case anyone needs something done right now. I'd like to give you a quote from John Adams from the musical 1776 because it kind of sums up how most people feel about attorneys. I've come to the conclusion that one useless man is a disgrace. 2 useless men are a law firm, and 3 useless men are Congress. So there you go. Now we all have, I'm not sure if all of you have heard this, but I've heard the phrase, no one loves an attorney until they need one. The same can be said, ironically, the same can be said about business executives as well as information security professionals. And why is this? Well, we tend to be overeducated. No one loves that. Everyone thinks we're way smarter than we need to be. We tend to be overpaid. Once again, no one likes that. They want to be overpaid. And then 3, we have to make difficult decisions that no one else likes. And what's especially interesting is the juncture of business, information security, and law represents some really difficult decisions that involve all 3 aspects. And yet, business people hate dealing with lawyers. Business people don't want to pay for information security programs. Business or information security people don't really want to study the law. And frankly, they'd much rather be doing the technical work than the business side, at least on average. And then you've got the Luddite lawyers who want to avoid everybody. So it's like there's very little communication. And why is this relevant? Oh, forgot, I have to say this. I thought all the legal disclaimers for all the presentations, very cute. I'm an attorney. I put a much more serious one up there. Basic message, same as everyone else, which is what I'm saying is my advice or my opinion. It doesn't represent legal advice. If you have a legal issue, please consult an attorney. This is not the appropriate venue for consulting this particular attorney. It does not represent a client contract, blah, blah, blah. Anyways, in all seriousness, this is how I picture the juncture of business, information security, and law. And you'll notice that there are multiple levels, all going different directions. You've got people in cars or groups in cars going all sorts of places. And it's a lot like what happens in business and information security and law. Because what happens is everyone's in their car, they're going different places, and they never see each other or talk to each other unless they're in a car accident or they hop out of their car because there's an earthquake or something like that and they're all having to talk to one another. So there's very little communication that goes on. So what I'm going to talk about, the rules of the road, basically the laws, and I'm going to go into nauseating detail. Okay, maybe not this morning for the number of people who are here and for those who are not over. How many people? Never mind, I won't ask. There's foreign law. What I'm going to do is federal law, state law, and foreign law. And then I'm also going to help you understand the dangers or the risks of the road. And I'm going to take it from a customer perspective and an employee perspective. And then finally, looking ahead, how can you take charge of your driving, be a little bit more of an offensive driver so that you can avoid the issues that people run into, and maybe some ethical considerations. Before we get into the laws, I wanted to show you an infographic you've probably seen, or if you haven't seen, it's kind of entertaining for me at least, which was, these are the breaches, data breaches, that have occurred over the past, 2005 through 2018. And you'll notice in 2018 that the number of data breaches as recorded by this group, went down. They went down, I believe it was 1244. And yet the number of actual records, the number of customer or consumer records went up. And it was 446 million records. So it appears that people, when the bad actors are performing data breaches and gathering information, they appear to be getting more information or better information than they used to. If you take a look at the beginning, it was very light, and it's got that nasty upward trend. The FBI reported in 2018 $1.2 billion lost just from email-oriented bad acting. So, this is my take on the law. They love their acronyms. Oh, pardon me for a second. I'm actually going to take this off. You don't have to actually have a coat on to perform or to practice law, but sometimes it helps. So these acronyms are laws at the federal level, and I'm not sure how many of them you all know, but I'm going to go through and give you my interpretation of the law's name, and then I'll use the actual law's name as I walk through. So we've got CFA, C flipping alligators. We've got NIPYA, HIPYA, GLBA, this is especially appropriate. Geeks love beer authentically. There's the Homeland Security Act, which we've all heard of, Patriot Act. Did you say FISA? There's socks, everyone needs a new pair of socks. There's PCI, or Paymentus Quietus Interruptus. There's EFTA, COPPA for Coppa Joe, Can Spam, which we've all heard of, obviously with the can of spam, FACTA, DMCA, which we all love, and TCPA for TCP is awesome. And then there's some industry-specific laws, FISMA, FedRAMP. FedRAMP is where all the cool kids skateboard nowadays. There's NERC, which was mentioned in a presentation yesterday, and that stands for Not Exactly Rocket Science. I'm not too good with following the letters. And actually, the NERC regulations kind of are rocket science in some ways, so it's especially funny. There's high-tech law, which is in the healthcare industry, and then CFATs. Now, I'm actually going to use the real titles, but in reality, I'm not going through all of these laws. I'm putting them up here so that you can look at them, and afterwards, if you're really interested and you go and take a look on the website or wherever they decide to post these. You can take a look at the laws and research them ad nauseum. The ones that I think you need to be especially aware of as an information security professional and a business leader would be the Computer Fraud and Abuse Act. That's the one that basically is the basis of most of why we do what we do. It's the accessing computers with unauthorized access of computers. That's the one that was passed originally that says, unless you've got a reason to be accessing this government computer, you shouldn't be on it. And nowadays you've got a disclaimer that's much longer than the one I had. That's whenever you go onto a government computer. Closely affiliated with that is the National Information Infrastructure Protection Act. And that one is the one that expanded, that's the law that expanded the CFA onto non-government computers. Plus it also said, not only can you not access it if you're not authorized, now if you damage it, there's an issue. So malware, spyware, that sort of thing, that's where that started taking effect. HIPAA is one that we've all heard of, but the only net effect that I've seen of HIPAA, I mean, other than the data breach notifications that we have to deal with, but in all seriousness, the only net effect of that is when I go to the doctor now, I have to fill out like 3 forms and sign them saying that they can distribute my information to whoever they need to distribute the information to. They're not going to specify who they're going to send that information to, but they're allowed to do it, which actually makes me feel kind of like the law is almost doing the reverse of what it intends to do, which is protect your information, because now you don't even know where the information is going and you're signing off on it. So that's pretty awesome. DMCA. I'm sure everyone who's been in the business for any length of time knows what DMCA is. Basically, it's the whole, we're going to try to lock down what people do with digital recordings, digital software, pretty much everything, digital rights management. There's much more to it, but that was one of the things that, frankly, over the course of the last 2 days, this is one of the laws that probably was broken once or twice, or at least mildly stepped on. So now there's the Children's Online Privacy Protection Act, and this is one that I don't know how many of you actually know about. You may have heard of it, but you probably don't know what it actually does. It protects children 13 years or younger, and that's all it really protects, that and some people with people with disabilities. And what it requires is that in certain situations, for example, when children are going onto a site that is either charging them money or has inappropriate material, that you have to get parental consent. So Net Nanny, Safe Site, and those types of sites now exist strictly because of that law. A final law on this particular slide is the Graham-Leach-Bliley Act, or Geeks Love Beer Authentically, as I like to remember it as. That was an act that was passed strictly for financial institutions because they were having a problem where financial institutions were releasing information or were having breaches and not much was being done about it. This basically mandates that financial institutions have to have some sort of program to protect their financial data and their consumer data. And in my mind, this was one of the first ones that took a pretty serious approach to it. The U.S. Patriot Act, go on, the Homeland Security Act. I think my icons moved a little bit because the socks are now next to the Homeland Security Act. Okay, I like it. Okay, Sarbanes-Oxley. How many of you have heard of Sarbanes-Oxley? Okay, I won't go into much detail. Basically, it says, all you executives, you've done some bad things, okay, so now we're going to have you sign off on your financials. And the reality is, I now listen to CLE, or continuing legal education classes, on how can executives sign off on things and still maintain a lack of knowledge about what they signed off on. It's like, I mean, yeah, exactly. Not that it's stated that way, of course. There's also the Can-Spam Act, and I'm not sure if any of you have heard of it, or, okay, a couple of people have heard of it, but the funny thing is the act intended on making our lives better by getting rid of spam. I still have more spam than ever in my box. And the irony of the act is that a lot of states were actually passing spam laws at the time. And so they were looking to prevent spam. This act superseded their efforts, and now it's being called the You Can Still Spam Act because it effectively doesn't prevent spam at all. Pardon me, I'm going to go back. And then finally, the one I wanted to point out isn't a law at all, and yet it's one of the most important ones for retail and even for big business like Cisco. I work for Cisco as an engineer. And so anybody who takes credit card transactions, PCI. Have we all heard of PCI? Yeah. PCI DSS is one of these standards that we're expected to follow. And it basically is how do you protect credit card information and the consumer information? The reality is it's not a law at all. It's covered under contract law. So when you sign up with a credit card processing vendor, they say, here's what you have to do to protect the information. Here's the standard we've designed that you must follow. The reality is if you don't do it, there's not a cop that's going to show up at your door. What is going to happen is they're going to raise the percentage that they charge you for your credit card transactions, or they're going to prosecute you under contract law. They're going to take you to civil court and sue the bejesus out of you and get lots of money if you have any money, although they're the ones giving you the credit. So you would think that suing them the other way would actually be much more effective. That reminds me, I think that's maybe something on Monday morning I need to look up. So, now those were all just general, broadly applicable federal laws. I mentioned NERC before. NERC is the National or North American Reliability Corporation. And so you say to yourself, it's a corporation, it's not a law. You're absolutely right. there was a law passed that basically established NERC, and NERC came out of a prior group called NERC. Yes, NERC came from NERC. And NERC, when they became NERC from NERC, they found out that they also, as part of the provisions of the Act, had to become what was known as an NRO, or a National Regulatory Organization. As part of that, they said, well, wait a minute, are we that organization? The Act didn't say that, so they actually had to apply to become an NRO, but they were made the NRO. And what that does for you is their regulations and standards, the ones that they set, are now the ones that they can regulate. They can actually, unlike many agencies or unlike many groups like PCI DSS, where it's not a law at all, they can actually take their regulations and go to the specific violator and prosecute. Or at least they can bring them up with charges. Now, HIPAA, I'm not going to go into, we all know about that. Graham Leachley, that's fine. Payment card. I think the only other interesting one out of this, from my perspective, is the Chemical Facilities and Anti-Terrorism Standards Act. And how many of you have heard of that one? Okay, so there's one person here in the room who had heard of this one. And so this is interesting to me because it's an industry-specific act, but it actually affects way more than what they're talking about. You would think that by the title, it would apply to chemical facilities, but oh no. Chemical facilities are broadly defined. Basically, anybody who has a certain number of a prohibited chemical over a certain quantity becomes subject to the act. That means academic institutions, corporations, individuals in their households. Not joking about that because hopefully you don't have that much of any of these chemicals. But it represents the idea that sometimes when we're in business and we're doing information security, there are federal laws that are broadly applicable, and there are industry-specific ones that you also have to worry about. In general, if there's industry-specific, for all of you who aren't big into the law, you've got the Constitution. That's like the Mac Daddy of all law in the United States. We all learned this in our government class. You've got federal, you've got draw little dots to a circle underneath saying industry specific, then you draw a super long line that goes roughly down to the floor in a little bubble called state law, and then you've got this nebulous cloud over here called foreign law, and sometimes it kind of meshes over federal. And so that's how I'm kind of looking at it. So why do you care? Okay, federal law, it's way far away. People passing laws in Congress and in DC, and that's what they do. And frankly, why do we care? Well, if you take a look, businesses are getting there's increasing amount of enforcement for all of the laws that have been passed. I think there's increased sophistication for understanding how to apply the law to technology, even if a understanding of the technology is not necessarily there. And these are some of the cases that have come up recently, when I say recently, in the last year. Anthem had to pay the Office of Civil Rights $16 million for a HIPAA breach. You've got the SEC in January announcing that they are prosecuting, I think it was 5 or 9 hackers who were grabbing Edgar documents and messing with Edgar documents for the SEC. The CAN-SPAM Act, believe it or not, actually got somebody to pay some money. There's a company paying almost $1 million because of unsolicited marketing. And then finally, a teacher was sentenced to 3 years, that's criminal law, was sentenced for a hacking case. So things are happening and people are being prosecuted. And this was just me going out and taking a look, like literally saying what kind of prosecutions have occurred within the past couple of months and putting a time frame on it. There's a lot that goes out, or a lot of cases that are being prosecuted, and you could put page after page after page. This is, for me, the reason you should care is it's out there and it's happening all the time, continually. Even your business may be involved in legal cases that you're not aware of. So, I think state law, even though it's in a bubble, way down by the ground there, and it's very small, I think it's actually more important because I think it's more relevant to us. And out of all the states, there's something about California that we all have to love. I came from Wisconsin originally, and dang it, California wants to steal our freaking cheese, okay? They've got all the agriculture, they've got Arnold Schwarzenegger, and now they want our cheese. I'm not good with that. The one thing they do pretty well, though, is pass cybersecurity or technology-oriented laws. They do have a lot of very focused individuals who understand technology. And so one of the laws that they passed is one of the first well-written, effective identity theft data breach laws in 2002. It's Senate Bill 1386. And for anybody who deals with residents of California or has a business in California or does commerce with California or sits and thinks about California or potentially might live in the same state or country as California. Basically anything to do with California. If you're doing business there in all seriousness, it means that you are subject to this law. So if you have a data breach in North Carolina, and it involves any residents of California, you have to notify them. And in addition to having to notify their attorney general, you also have to ultimately contact those consumers who have been affected. What's interesting about it, and the reason I mention it, California has a really good one, but all 50 states, every single state has a data breach notification law of some variety. So you do need to be aware that not only at the federal level under Consumer Fraud Abuse, Electronic Communication Privacy Act, there's a number of laws that have provisions related to data breach. Each of the states also has one, and it may have different requirements that you have to take a look at. California also, interestingly, there's the word encryption has been mentioned once or twice over the course of the past couple of days, and encryption is becoming increasingly important, and California defined it. So they went into one of their laws, and right up front in their definitions, they defined what encryption was. Now, personally, whether or not you agree with their definition of encryption is not as important as the fact that encryption was defined is important, because it means that legislators are starting to be aware of technology and put words into the law specifically related to it. So that's going to constrain our behavior as information security professionals. So what they consider encryption can affect, for example, ROT 13. Is that encryption? It's technically under the definition of encryption by California standards, yeah, it is. Now, is it effective encryption? That's a totally different argument. Double ROT 13. Now, in terms of other laws, state laws that are, I haven't gone into the North Carolina ones, but the other state laws that are non-North Carolina. How many people are not from North Carolina here? Okay, so just to shout out where you're from.
Georgia.
Virginia. Wisconsin? All right. So, Minnesota, all right. So you know my pain about them stealing our cheese, right? All right. By the way, F and Bucky, so. Anyways, I'll mention Minnesota since someone talked about it. They were one of the first states to adopt the PCI DSS standard, at least partially, in law. So what they did was they actually took the wording from the PCI DSS standard and put it into law. And you're starting to see that more and more, where the law is looking at the people who actually understand the technology and using their words. And what's interesting about that is not only Minnesota did a partial adoption, Nevada did a wholesale adoption by referencing the PCI DSS standard. So if you look in the Nevada law related to credit card processing, it says, we as a state or as a legislature have decided to adopt this standard. Whatever latest version they have on file is what is law in our state. And that's kind of scary in a way, because it's basically abdicating the responsibility for what the law is to people who know the technology, which is kind of cool in the sense that it's putting responsibility where those people have the knowledge. But on the other hand, those people don't know the law. And so when they write something poorly, or when they define a standard and that standard doesn't go through sufficient review, that should scare you a little bit. Let's see, what out of the rest of this, the Vermont with the data brokers, places that collect information, they passed a law where you have the ability to opt out. I don't want to be part of your data collection. And you'll see this in another slide, not specifically related to Vermont. Now what I find, let's see here, California, okay. So as I said before, you've got, writ large, you've got computer crime. And this book, when I went to law school, was the extent of computer crime. Now I went to law school in 2010, so it's not like it was that long ago. But when I went, I was super excited for the class. I go into class, I did it as a second career. And so I'm pretty passionate when I get involved in things, and I've been a computer person for a really long time. I sign up for the class, and normally when you go to a law class, you get 4 books. Like you have to buy 4 books, you spend some ridiculous sum of money. This had 1 book. I buy the book and it's this thick. Normally the books are like twice as thick and you've got 4 of them. I'm like, really? So I literally read the book, scanned through it overnight, walked in the next day and said, WTF. This is all wiretapping and telegraph law. I mean, literally telephone wiretapping and telegraph law. And my instructor at the time, the professor, he goes, yep, that's what most of the law is based off of. You've got to be kidding me. So if you're wondering whether or not legislators and lawyers are a little slow in adopting technology, that might answer a question. But writ large, you've got computer crime. And computer crime covers things like unauthorized access, damage to computers. It encompasses a lot of things. And I'm going to kind of walk through the state of the law in the United States. Computer trespass covered by all 50 states. Data exfiltration covered by all 50 states. So data breach, you've got it. Hacking tools. In Europe, there are some places where just owning hacking software is against the law. I believe Germany or Austria is one of those places. Ransomware and computer extortion. There are 5 states currently that have laws specifically about that. There may be more, but those are the ones that I know about currently. Now for malware and for spyware and viruses, about 1/5 of the states have laws. Denial of service. There are actually laws about denial of service for more than half of the states. There's phishing laws, half the states. Now these are all state-oriented laws. Kernel fuzzing, which I thought was especially appropriate. Now, that is without fair use or exception. So in other words, if you're doing kernel fuzzing and you are not doing it for the purposes of interoperability, trying to make this work with this, and if you don't have a legal right to be doing that reverse engineering, about all 50 states under contract law, that's against the law. So it's the person who did the kernel fuzzing presentation here. Right. Yeah, exactly. Blockchain and cryptocurrency was, to me, it was a really fascinating, and it hurt my head, the presentation. I was just like, oh my God, the complexity of it is amazing. About 1/5 of the states have passed laws. The interesting part is, on one end of the spectrum, you've got the states who are like, yeah, cryptocurrency, woohoo! And then you've got the other half, or the other end of the spectrum, which is like, oh, hell no. No, you can't do that. And so the laws there are all over the place. From a personal perspective, I think blockchain is going to be a technology that we use both in business, but I also think it will apply to the law eventually, because it's one of these ways where you can have things be authenticated and verified by a wide body of people. Well, what are laws, right? Laws are basically rules that we have that have been authenticated by a group of people. The way we authenticate them is by electing people, or by people remaining in office, even though we didn't necessarily elect them. So that's the state of state laws. North Carolina. So a lot of people are here from North Carolina. We do have a data breach notification law. If you're concerned, North Carolina General Statute 7565. Enough said. Computer crime laws writ large, cyber stalking. The very first presentation, or the second presentation, was a discussion of a private investigator contacting friends of the person they're actually investigating. Technically, under cyber stalking, that would qualify. And if you didn't have a legal reason to be doing that, you could be prosecuted, even as a private investigator, because private investigators have pretty narrow lines to follow sometimes. There's my favorite under North Carolina, other than alienation of affection, which I have actually written up a complaint for, which is pretty awesome. That's a legal thing. The disclosure of private images, or revenge porn. So, anyone been prosecuted for revenge porn in this room? Anyone want to admit that they've been? This is where you basically post a picture of someone's private parts, or of them with their private parts exposed without authorization or without consent, without it's unauthorized. It has to be out to public, to public review. There's lots of elements to the crime. But basically, if you post bad pictures or post racy pictures out in public, be aware, North Carolina's got you covered under the revenge porn law. There's also solicitation of child by computer. Hopefully we don't have to deal with this at all. This is just one of the laws under computer crime. There's banning the use of social networks by sex offenders. To me, this was kind of an interesting law because you don't even have to do anything wrong. But if you're a registered sex offender and you get found out that you're going into, don't ask me why that switched, if you're going into social media sites and you're doing it for the purpose of following someone that you shouldn't be following, and you get brought into court, this is what gets applied and basically says you can't go to social media sites anymore, okay? And this is why. Accessing computers, damaging computers, this is the same CFA, NIPA or NIPIA. And then finally, there was a cyberbullying law, which I found pretty interesting from a civil rights perspective, because cyberbullying, there's that fine line between the First Amendment and what you can say online and then what you can do related to an individual. It was struck down in 2016 as unconstitutional by the North Carolina Supreme Court. So if you've heard of that law, it's no longer active. Now, that being said, why should you care again already? Apex woman first charged, and I picked the woman because I thought this was fascinating that a woman was the first charged under the revenge porn law. I thought for certain there'd be like 80 guys charged under North Carolina's revenge porn law, but no, it was a woman, believe it or not. A state legislator is actually being brought up on charges of cyber stalking right now because of a custody case for his children, which is just, like how these laws get applied sometimes, it just is fascinating. Employees filed suit against ABB. So in North Carolina, there's a data breach, identity theft case in the works. Basically, it's going to be pretty high dollar. And if you take a look at the North Carolina federal court has allowed a treble damages, in other words, triple damages claim in an employee data breach. I mentioned that the laws have both a customer focus and an employee focus. This one is unusual in that it focuses on the employees. When it comes to consumers, courts are very quick to say, we're going to give you lots of money, or we're going to make sure there's recompense. And not always the case with employees. So we've got federal covered, we've got state covered, and like I said, I think state is actually the most relevant in some ways to our personal lives, but foreign law is becoming more and more important. And I've got all these countries covered. The reality is that there is one that is going to affect us. It is affecting us. It is going to affect us even more, and you all know what it is. It's GDPR. It's the General Data Protection Regulation of the EU. And writ large, it says we want to give the right of personal data, the right to control that personal data back to the people who it is actually concerning. So it's the individual. And this comes from the EU, which tends to have a more, what I would call, principles-based approach to the law. The United States bases our law primarily on what's been done before. So it's like, which one is not like the other one? And then this one's outside of that. Well, is that a good thing or a bad thing? It's a bad thing. Okay, so we're going to go back to which one's like the other one. You know, it's very, very precedent oriented, as was the UK. But the EU, I went to study when I was in law school. I went to study over in Germany for a summer. And one thing that I found fascinating about their law there was they start from a principle of, or they start from a principle, and they say, we believe the following. We believe that this is right. And in this case, GDPR basically says we believe that individuals have a right to control what gets put out about them or what gets collected about them. And so they pass a bunch of regulations or laws that are specific to that. GDPR says something that the individual has a right to opt out. If you collect data on a resident of the EU, it's not necessarily a citizen of the EU, but a resident of you, that you are obligated to give them the option to opt out. Even if they opt out, you still have to provide them service, which is interesting because if you don't know anything about them, how are you supposed to provide them service? But obviously there's ways of doing it. They have the ability to request a right of erasure, or they have a right of erasure of the data that you're collecting about them. In addition, you also have the responsibility of providing that data that you collect about them in a portable format so that if they want to use that and go somewhere else with that information, or even just to know what's being collected about them, they have that right. Additionally, they have the ability, or they have the right to understand what you're collecting as well as every single use that you're putting that data to. So say, for example, as a US corporation, which a lot of us work for, you go to a website, they ask for your name. Okay, great. You have to be able to tell them why you're collecting that name. And if that name collection is not specific to the individual, but it's actually more of an aggregate sort of informational collection, they need to understand that too. If there's something specific to why that information is being collected, for example, marketing, you have to say, we're going to be marketing to you and we want to market specifically to you. So it's a pretty broad-reaching law, and already, once again, why do we care? We care because Google was just fined 50 million euros because they did a cruddy job of implementing GDPR protections. What did they say when they were confronted? Hey, we've been spending the past year and a half trying to set things up so that we're compliant with GDPR law. Now, if Google can't do it, and Google's got some of the smartest minds on the planet working for them, do you really think your company is going to be GDPR compliant? The one benefit, or the one nice thing about what we do for a living is that information security has a carve-out under GDPR. It's actually required to have an information security program of some variety. And as part of that, they understand that you have to collect data. That being said, if you collect the data and you apply negligent practices to storing that data or using that data, you can probably be prosecuted or you can be fined. What does that mean? Do you encrypt the data at rest? Do you encrypt the data in transit? Let's see. I'm going to go into the risks of the road because this kind of ties into that right away. The privacy and data breach risk is huge, right? We all know about it. We all seen it in the news. And part of what GDPR said is the middle bullet there, which is you need to consider using encryption. And in fact, a lot of the state laws that I mentioned talk about having to encrypt things at rest or in transit. Under the data sovereignty risks, I'm actually going to go through them afterwards, but GDPR mentions data abstraction. They actually call it data pseudonymization. Say that like 10 times fast. It's making it difficult for an individual to re-identify someone from the data set that you have. It's not to make it impossible, but it's to make it difficult. Now, I would say that in general, there's anonymization, which is taking that data and making sure you can't figure out who it was in the first place, and then there's pseudonymization, and then there's just raw storage of information. So the risks of the road. You've got data breach, identity theft, privacy. I think the loss of privacy over the course of the last 50 years has been extensive, to say the least. But it's been primarily focused, all the laws have been primarily focused on the customer side. And in fact, almost everything I talked about started from a consumer-oriented perspective. That is changing. More laws and lawsuits are being brought forth on behalf of the employee and what gets done with their information. And so be aware of that, because as information security professionals, a lot of what we're doing is we're monitoring what's going on in the workplace and what our employees are doing. And ironically, a lot of what we do for a living is authorized under something known as the Electronic Communications Privacy Act, or ECPA. It wasn't even a law I mentioned before, because frankly, it was a law that was passed to protect people from the interception of electronic communications. So it was specifically put into place to protect people from having someone step in between and say, oh, that's the email you're passing to this person. But the irony is, one of the exceptions to it is a huge exception for business, which says if you own the property that the employee is using, you have a right to monitor it. Hence why we can do what we do for a living. So I think that you're going to see a huge risk over the course of the next probably 5 years. You're going to see an increased growth of employee-oriented suits. Encryption obviously is more important, and also retention. You see laws with maximum retention dates or retention time specified. You haven't seen a lot that have a minimum retention time specified. As information security professionals, consider how long you need to retain that data to prove out, to keep the evidence of what's occurred for a given incident. One thing you may want to do is you may want to, as you're writing the play, also write up and clearly document why you need to store data for as long as you do. Because when it comes time to go to court, you can say, the reason we stored this data for as long as we did, which was, of course, less than the maximum time specified by law, but the reason we stored it for 6 months versus 2 weeks, because this could be touched upon by GDPR.
I think CALEA has a minimum on storage of data.
Okay. A gentleman said that the CALEA law has or the CALEA Act has a minimum specified. And I'm sure there are some that have minimums, but it's not one that I've seen specified very often yet, which I always find interesting. It's like we're worried about how long we retain it, but not about the minimum amount of time we retain it. In some ways, that's actually more important. For example, in criminal law, the police officer cams, when they're going in and arresting somebody, there are a lot of regulations on the books that basically don't specify how long they can hold that data. And it's, that's a huge civil rights privacy issue as far as I'm concerned. Data sovereignty risks, you've got abstraction, anonymization, pseudonymization, the locus of the personal data, where it gets stored. Germany, France, Russia, China, portions of the GDPR specify it. Basically, if you're collecting data about someone in Russia, Russia is now saying, we want you to keep that data in Russia. China's the same way. France is the same way. A lot of the work that I do is around cloud security architecture, and I'm seeing that more and more, where more of the projects that come up, okay, how do we architect things in such a way so that we can perform information monitoring, but it has to be over in this country and things can't leave the country? That's a huge risk, both in terms of business cost, business opportunity lost, legal exposure. I mean, that's that juncture I was talking about, that all of these touch upon it, but that kind of data sovereignty risk is going to be huge over the course of the next couple of years. And obviously, as I mentioned, control of personal data. Some other risks, surveillance risks. This is more on the employee side. We all know we can monitor computers, email, messaging, blah, blah, blah. That list, as you notice, the further down it goes, when you get to GPS and social media, those are where the law cases are occurring right now. And this is the cool stuff. I mean, from a legal perspective, if you're a legal geek, is the questions you have to ask yourself are, Is the person on company time? Is the person using company equipment? Is the topic by which they're discussing a company-oriented one, and is it one that's covered under the First Amendment? There's a lot of issues. There was a case that was brought up where 5 people went out onto the internet. They were all co-workers. They were all discussing work. They were discussing work about an upcoming meeting, and yet even though they were discussing it, because someone said something negative about the company, they were terminated. First thing that turns around, they got terminated, they sued. So there's going to be more cases like that where people go, we all know that companies go out and research us on social media. My social media, I try to make it as entertaining as possible, so I'm more likely to get hired, but I'm joking. If you look out there, I'm pretty boring. But I think that's a huge risk in the future, is that it's a risk from both sides. It's a risk from the perspective of the company and what they do and whether or not it's against the law and the lawsuits that it's going to incur. And it's also a risk from our personal side, right? We're giving up privacy. Whether or not we post something, even if it's out in public, because say, for example, if I'm with a group of guys and we go tossing a beer and we're sitting and talk about work and that gets overheard by somebody, that's still in public. Didn't used to be a lawsuit about it, right? What used to happen is the guy's being an idiot, he's drunk, whatever, and you didn't get terminated. Social media, it stays in writing and you can essentially look it up. And I think that's why companies are concerned, is because it affects their reputation in a much more long-lasting effect. The ECPA, I mentioned about the fact that monitoring is allowed under it. The enforcement continuum is also a risk of the road, in the sense that there are laws and there are jurisdictions that have a laissez-faire approach to law enforcement related to computer crime. They're like, yeah, computer crime, it happens, but I'm really much more concerned with the serial rapists, the thefts that are going on, the murders that are going on, and so that's pretty low priority for us. And then there are the other states or the other localities that are totally different. They're like, oh God, no, computer crime, that's bad, and that's the worst thing in the world, so we're going to kill everyone. Okay, maybe prosecute everyone. Go maybe a little overboard there. Some other risks of the road. If you're into the cloud at all, there's a shared responsibility model, and to me, that shared responsibility model is an opportunity for huge lawsuits, because you've got the CSP or the MSP, which is the cloud service provider or the managed service provider, that says, we're going to take care of this portion and we're responsible for this portion, and anything outside of that is all you. And yet, if you sign up with them, they send you notices about bad things going on within their resources that are at your level, above where they're supposed to be monitoring. And so they're also under an obligation, if it's a clear violation of the law, to notify the authorities. So not only are you supposed to report, they're supposed to report. What happens when they report before you report, or you miss it and you don't report and they report? Are you legally liable at that point? Another risk related to that, your legal privilege. Let's say you don't encrypt everything on disk when you're storing it in the cloud. They, meaning the CSP or MSP, can be legally compelled to provide information about what they have in terms of resources and documents and that. Does that also mean that they can be legally compelled to present information that is within the resources that they provide to you, but you are responsible for configuring, but have configured poorly so they can see them? Legal cases are going to be decided over the course of the next 5 years. You don't want your company being the one that has all the documents thrown out into discovery that were sitting in the cloud. Plus, yeah, go ahead.
So about encryption data at rest.
Yeah.
Have you seen specific legal requirements that it be beyond disk level? It's at a file level?
I haven't seen that so far. Most of them are just at the level of encryption would be a really good idea. Encryption would be a really good idea. Now, there are some standards that are enforced. One thing that I didn't really discuss is FedRAMP. and I deal a lot with FedRAMP. And so FedRAMP relies upon something called the NIST standards, and I'm sure you guys have all heard about it, the 800-53. And so FedRAMP uses that as the standards that if you want to do business with the federal government in the cloud, you effectively have to follow the FedRAMP standards. And you have to go through a FedRAMP program. You get something known as an authorization to operate, or an ATO. And as part of that, encryption is required, but they don't specify. They just say, encryption's really good, you have to go do it. Okay, I think, yeah.
So if you're a customer of a company that uses, say, AWS for services, under GDPR, can you petition AWS as well for your information, or are they obligated to provide it?
You know, that's a good question. I think it would be challenging based on the terms of agreement or the contract that you sign with them. They probably have a provision in that they are not responsible for providing anything, that it's all your responsibility from your level on up. And the only things that they are going to be compellable for by you for discovery purposes. Now, the reality is it can go much broader, but they're probably going to try to limit their liability to just those things that they directly control. And it's pretty sweet for them because they're providing a service, and yet they're in such high demand that they can basically have some really unreasonable, and people just sign off on it. So I think there are two other risks that you need to be aware of. You have all the risks that you are subject to, but when you're dealing with a cloud service provider, you have to also consider, you have to go through your due diligence and see how they also protect themselves in their portion of the stack for all of those things. And finally, increasing complexity. I'm talking about the intersection of business, information security, and law. That's complex. Each one of the groups is complex. There's lots of complexity related to all of that. There's lots of room, and it's only getting worse. There's lots of room for gaps. So you're going to continue to see more and more lawsuits. So looking ahead, how do you take charge of your driving? Well, first of all, I'm going to say the thing that everyone says, blah, blah, blah. Establish an incident response plan and a playbook. I am neither promoting nor endorsing. I am using as an example this book here, which is Crafting the InfoSec Playbook. This is a great example of how to do it. It's not necessarily a one-size-fits-all, but it gives you all the principles. And you need to understand when it comes time for a lawsuit, or when it comes time to prosecute somebody with the evidence that you've collected, you need to understand what your chain of custody program is. You need to have that defined. You can't make it up on the fly, because when you bring that evidence into court and they say, well, how can you prove control of this evidence from point A to point Z? And you can't, gets tossed out, and there goes your case. So design systems with the future in mind, right? So if you're seeing words like encryption being defined now, you certainly need to start using it. But you also need to consider the needs of the future. Is there a way you can protect data in a way that maybe is forward thinking? For example, just sitting and getting ready for this presentation, I was thinking it would be best, not only do you anonymize data where possible and you pseudonymize data where possible, you also set up not just an RBAC system where it's role-based, but you set up one where it requires more than one person to re-identify. So an executive can't go in and find information about a consumer, or an information security professional can't say, oh, hey, that guy's pretty hot. I'm going to look up his address. Can't do it. You'd need two people to be involved, and I'm saying either direction. I was using a generic example there. Pardon me. That's my legal background. Please don't sue. Okay. White hat hacking. Is it alive and well? Yes. Lots of classes out there. Are you violating the law? Very possibly. So you talk about hacking all during this conference, and the reality is when you sign when you sign off on the agreement with your company to use the equipment, you probably also agreed not to scan the network. So you can't use Nmap, you can't even do a telnet to a port if it's for the purpose of figuring out whether or not that port is available. Now the reality is, are you going to be prosecuted, especially as an information security professional? Probably not. But be aware, what you're agreeing to has legal effect. And it's not necessarily when you're doing it, but it could be a year or two down the road where you're doing totally different responsibilities, and some court case comes up and they said, did you scan the network? Well, yeah. Were you allowed to? Well, I worked in information security. Did your duties require that you scan that particular device? No? Okay, thank you. Next. And I mean, that's the kind of thing that happens in court is cross-examination and these very specific questions, what you're doing. It only takes a single mistake to make a court case go the wrong way. Reflect on the security versus privacy balance. For me, this is huge. I'm always sitting and thinking about what I'm doing and whether or not it's going to impact someone's privacy. I hate to think that the systems I set up are destroying the fundamental privacy of the people that I work with, right? I don't want to be thinking that, you know, this guy here, I'm collecting data about him and other people can look at that data and make judgments and decisions about his life. I pick him out specifically because I know him. But you take a look at it and you go, is this something we really want other people doing about us? Anything you do and anything you set up, think about how it would affect you if it was applied to you. Some final bits of advice. Seek legal counsel when necessary. And I'm not saying that because I'm an attorney, because you're never going to talk to me. I mean, the reality is the people that come up to me say things like, hey, I've had a speeding ticket. Do you know any good speeding ticket lawyers? I'm buying a house. Anything I need to consider? You know, they come up to me with things like that. No one's going to come up to me and say, hey, I'm getting sued for, looking at inappropriate images online. It's the type of thing you want to have a relationship with counsel before you run into an incident. So, and if you hit an issue that is way beyond your expertise, don't solve problem, right? Don't do what we do for our jobs. Don't try to solve the problem yourself. Don't go online and do research and say, oh, here's where the law is and I understand the law. I guarantee you don't. Part of going to law school is understanding that the mentality of a lawyer, they can use the exact same words as you and it does not mean the same thing. And that's my best bit of advice is lawyers don't say what you say. They can use the same words and it's like that. Finally, make 3 or more friends. And my wife, when I was telling her about this, she looked at me and she said, you are such a geek because you don't make friends with these people. And I said, well, this is a relative thing, right? Make sure you know who inside counsel is. Talk to them. Say, I'm part of the information security program. Is there anything I can do to help support you? More importantly, is there anything I need to do if I'm bringing you a case? And if you're not responsible for that, if you're an analyst or an investigator or you're at a pretty low level and you're not actually going to be contacting counsel, understand what that chain is. Who are you going to be contacting or who are you going to be passing this information off to? If it's inside counsel, make sure you know who they are and make sure you have a good relationship with them. Also, law enforcement. Don't call them up on the phone and say, hi, I'm Blaine Schmidt. I'd just like to let you know, I kind of like to know who you are and I want you to be my friend. Not like that, but know who your local law enforcement is and maybe consider going to events that they hold that talk about cybersecurity. I do that periodically. I go to something called InfraGard where they have the FBI presenting topics of cybersecurity interest. Just having that relationship and knowing who the people are will help. And finally, know who outside counsel is. And this is the most important part, is there are times where investigations will require what's known as an arm's length transaction, meaning that the person you're dealing with or the group that you're dealing with is not directly beholden to anyone in your organization. So the legal appearance of that is one of propriety. In other words, they don't have any buy-in and they don't have any advantage to keeping the data that they're keeping and presenting things the way that they're presenting. How would it look if I, as an information security professional, report into a director who is investigating, who is beholden to a InfoSec VP? That InfoSec VP is the one that's being investigated. That whole chain of investigation could be suspect based on that kind of, it's just the appearance of impropriety. We could all be doing our jobs. I'd want outside counsel in at that point because it's a very difficult situation for an individual in our business to be investigating somebody that they either report to or have a direct line of responsibility. Anyways, those are some of the ways you can help your driving improve on the legal roads, and I've identified some of the risks and dangers. Does anyone have any questions?
Yeah, real quick. And I'm not sure if you're familiar with this. Obviously, I work in the area of IoT.
Yeah.
There's been some recent IoT laws, Senate Bill 327 out of California. I don't know if you've had a chance to look at it. It's signed into legislation. It goes into effect January. It's requiring manufacturers to set certain security standards on IoT.
The question was basically, what was the law number?
327.
Do you know if it was a House bill, Senate bill? Oh, okay, 327. It was a California law, either a House bill or a Senate bill, 327, that talks about standards being applied to manufacturers for IoT devices. No, I haven't read it. Not surprising. The amount of law now existing about cybersecurity is just like phenomenally large. But that being said, I think that laws like that tend to get passed initially, and they either, much like the PCI DSS standard, will point to a standard that they can use, or they tend to fail or have to get rewritten over time. It's like the initial law is always like, this is really bad, we need to do something about this. And then people come in afterwards and they say, okay, amendment this, amendment this, amendment this. And it usually takes a year or two to, shake things out, if you will.
Why is it NERC known as NARC?
The question was, why is a NERC known as a NARC? I have no idea. No, there we go. No one likes a NARC. So, any other questions?
Virginia has a anti-spam law that says if you run a mail server and somebody sends a mail from wherever, Virginia courts now have jurisdiction. And if you run a mail server and they send spam, you're entitled $10 per spam. Of course, that means you can take them to court in Virginia and get a judgment. Of course, the judgment enforcing it in Russia or Ukraine or anywhere but maybe California is impossible.
The gentleman was saying that Virginia has a law about spam where if the spam reaches a person in Virginia, then at that point that Virginia essentially has jurisdiction over it and can fine you, a mail server in Virginia can fine you $10 per spam. But the issue, and I would agree, the issue is enforcement. You can say anything you like, but like you said, if the spammer is in Russia. Now, what might be interesting is whether or not they start prosecuting upstream. Basically, whether or not I'm interested in seeing over the next few years, whether or not the people who are passing that traffic are going to be responsible, because there seems to be an increased desire to have visibility into the traffic at the same time that there's an increased push for an encryption out and increasingly strong cryptographic controls on the traffic going out on the internet. So, all right, thank you very much, folks.